Hello, everyone. How are you guys doing? My name is John Crump, and this is John Crump News, where we cover 2A every day. I'm an investigative journalist that concentrates on firearms. Today, we're going to be talking about a letter that went out from a couple of attorneys to the Virginia State Police because they are being ordered by the Virginia Legislature to violate the a court order. So the legislature is ordering the police, and also the governor is ordering the police to violate a court order. We're gonna get into that in a second, but welcome to the channel, and yeah, let's go ahead and jump into it. Once I hit the right one here. Yesterday, the Virginia General Assembly accepted the governor changes to House Bill 1525. And you know what? The best person to let you know exactly what is going on here is the lawyer who wrote the letter himself. So let's go ahead and we'll just share the screen. We'll just read the letter here. So give me 1 second here. And let me just bring up the comments here. All right. So here's the letter. It is from David Brown, who's a good guy. Um, well, Calvin Brown, who's a good guy. And Peoples Burgess. And the letter reads, on April 22nd, 2026, the General Assembly passed the governor's amended version of House Bill 1525, amending and reenacting VA Code Section 1802-308.7. Now, case was this was already brought to court, and a judge ordered a permanent injunction. This is background checks, universal background checks. Part of the language contained in the bill, which originated as substitute language proposed by the governor, is Section 2, which states the Department of State Police shall administer, enforce, and otherwise implement Section 18.2, 308.2, subsection 5 of the Virginia Code from the effective date of this bill. There's a huge issue with them ordering the Virginia State Police to enforce it. There's a court order out of Lynchburg, which the anti-gun Democrats call the Lynchburg loophole. That is a permanent injunction against this. GOA and VCDL sued over universal background checks and got a permanent injunction for a motion of summary judgment. At the time, Jason Miyares, who was the AG, decided not to appeal, and so the summary judgment stood. If you recall back then, the current AG, Jay Jones, tried to intervene in the case, and the court said, no, you're not AG yet. You can't intervene and appeal because you're not AG. So it goes on farther by saying, as you know, the code, I'm not going to keep on reading that out again, is the statute generally requiring universal background checks for all private sales of firearms within the Commonwealth. And as you are also aware, the statute was declared unconstitutional with its enforcement and administration by the state police permanently enjoined. So the judge in Lynchburg said, you can't do this. It's permanently enjoined. Motion for summary judgment for VCDL and GOA. The law is dead. So the governor is trying to say, well, I'm just going to say we're going to enforce it anyway. As the Department of State Police website currently incorrectly summarizes, the order prohibits the state police from running or assisting in running of private sale background checks pursuant to the provision. Virginia law currently does not require criminal background checks for the private sale of firearms. Nevertheless, HB 1525 Section 2 demands precisely the opposite. purporting in plain language to require the superintendent, your client, to violate the court order that was issued on October 29th, 2025. That's the final order. Of court, a statute expressly requiring the violation of the term of the court order is null and void, dead on arrival, which it is because the legislature and the government can't order the state police to ignore a court order because that would be illegal. Indeed, we submit that HB 1525 shows a gross disregard of, even contempt for, the constitutional separation of power and the proper role of the judicial authority. As the Supreme Court has explained, an injunction duly issued out of a court of general jurisdiction with equity powers upon pleadings properly invokes its action and served upon persons made parties therein and within the jurisdiction must be obeyed by them. It is for the court of the first instance to determine the question of the validity of the law, and until its decision is reversed for error or orderly review, either by itself or a higher court, its order based on its decision are to be respected. Disobedience of them is contempt of the lawful authority to be punished. So we have something in the country and in Virginia called separation of powers. There's three distinct branches of government: executive, legislative, and judicial. What's going on here is the executive and legislative is trying to overrule the judicial branch on its decision, which is not allowed. But, we're in Virginia and the governor and the legislature doesn't seem to care about the Constitution at all. Likewise, the Supreme Court has explained that ratification of the Constitution forbids legislative interference with the final judgment of the courts. This goes back to the founding of the country. And these tyrants in Richmond want to just throw that all away. They want to be dictators. Thus, when the court upheld a congressional enactment that allowed for termination of previously issued equitable relief, it did so only because the statute did not directly suspend a court order in violation of the separation of powers doctrine, otherwise depriving judicial judgments of the conclusive effect that they had when they were announced. Violation of powers. And this is exactly what Richmond wants to do. The politicians from Richmond want to violate that power. They want the state police to say, we're going to ignore the court, we're going to ignore this court order, and we're going to do what we want to do. They want to have absolute tyrannical power to enact their draconian laws. Our expectation is that your client, the superintendent, will continue to abide by the court's October 29th, 2025 order unless and until the court empowered to do so acts in a manner that would relieve him of this obligation. Indeed, the court have long presumed that officials of the executive branch will adhere to the law as declared by the court. This is common. This is basic civics. This is basic separation of powers, yet Spanberger and the Democrats and the legislature in Virginia, the General Assembly, want to ignore that. If the superintendent believes or intends to proceed otherwise, please let us know at your earliest convenience. That's a shot across the bow. That's saying if you intend to do that, we will go ahead and we will go back to the court and get you for contempt of court. And that is a criminal thing. That could put the superintendent in jail. To the extent of the Department of State intends to remove its current and accurate posting as the present state of law from its website or otherwise intends to take steps to administer and or enforce the provision pursuant to HB 1525, please advise us promptly of the same so we can take immediate initial contempt proceedings in circuit court. This is saying that, hey, superintendent of police, if you do this, we're going to come after you and we're going to get you for contempt. And it's signed by David Brown. David Brown is a good guy. And let me tell you a little bit behind the scenes here. What I am hearing is that the plan is to go ahead and enact this early, to say, hey, we don't have to wait till July 1st. This orders us to do it, so we're going to disregard the court order and do it. The issue is that if anybody gets arrested for doing private transfers, I don't think it's going to hold up in court. But you still have to go through the process of going to court, which the process is the punishment. So what is going on here is the governor and the General Assembly wants the state police to ignore a lawful court order and violate that court order, which would pit everyone in contempt. Whether they do it or not, we will see. And if the superintendent does do it, pretty sure David Brown here, is going to be back in that Lynchburg court or the circuit court and getting a contempt order against them. Now, someone said out there they won't arrest themselves. Well, yeah, that is true, but the judge can order them arrested. So we'll have to see what happens. It's going to be interesting. The superintendent of police is in a precarious situation because he's going to have to ignore the General Assembly and the governor if he wants to do what's legal. If he bends the knee to the draconian, tyrannical, far left government that's in Richmond, he will be violating the law. And with that, we are going to get out of here. Just wanted to make a quick little update, let you guys know what's going on with this, because I find it very interesting. I have to do an interview in a few minutes with someone special. You should see that either tomorrow or the next day or the next day or the next day. So it's going to be an interesting interview. And yeah, it'll be live on the channel soon. With that, we're going to get out of here. Thank you so much for watching and see you later.